Good morning. Thank you very much for being here. 9 o'clock in the morning, the day after the party and GDPR. I think it's a triple whammy. Thank you very much for coming in. All of you, I think, have earned some kind of medal. I think there'll be people drifting in throughout the rest of the talk. We just have to keep going and thank you for being here for the beginning. So my name's Simon Crossley, and I work for a company called Consentric. And we've been working with personal data, managing individual rights, and helping organisations build trusting relationships with the personal data that they store. We've been doing this for a few years now for some very large customers, and we've been doing this since before GDPR came along because we thought, it's important, and the way that people process data needs to change because the individuals' lives around data are changing so much at the moment. So, there's some big stories in data protection at the moment. We all know about the episode of Cambridge Analytica and processing their data, and a lot of people getting on board with the delete Facebook movement, but actually I think the vast majority of people are still quite happy with Facebook handling their data. They understand the bargain that you make, that they'll take your data and provide ads and personalise the ads, and most people think that's absolutely fine. But with Cambridge Analytica, and if you take that data and use it for the purpose of subverting elections, then that's really creepy. And so it's all about the purpose of processing data, and that's something that's going to come up again and again. And whenever people say, can I hold that data? That's the wrong question. It's, can I process data for this purpose? It's always, what's the purpose in order to understand data protection. And GDPR is obviously legislation that comes into force on the 25th of this month. Everybody should really be well on their journey to GDPR compliance by now. Lots of people are not going to be. We know there's lots of last-minute panics going on in the market, and it's compliance. So no company has ever succeeded because of its world-beating compliance. It just doesn't happen. You do what you need to do, and then you get on with the rest of your business. And so with all of the sort of preparation that we've been doing, working with all these companies, the focus has been on what do you need to do, how do you process this data, and how do we get you back doing the things that are going to make a difference to your business. So that's really what I want to share with you a bit today, some of these learnings. I've been told that I have to include this slide. We're going to be talking about legislation, but I'm not a lawyer. I'm a developer. I can give you a pragmatic approach and tell you how to think about these things, and then it's your decision whether to seek legal advice or not. I think, if you go to the lawyers first, you're going to get yourself in a whole load of trouble because it's very, very confusing. But if you can understand the problem and then make your decision and ask specific questions, I think, you get the most out of the legal advice. And it's for the edge cases, because most people process a lot of data in the same kind of ways. So we can learn from the community on how to approach this, and then we only need to deal with special cases. So let's get to fundamentals. What is personal data? You'll sometimes hear personally identifiable information as being the term. That's the term that the American legislation uses. The correct definition in European GDPR is personal data, and it is any information relating to an identified or identifiable natural person. And that person is the data subject. So it's a living individual, and the identifiable part of this definition can be indirect as well. So GDPR broadens the definition from a lot of previous legislation and is more specific in what it includes. So it will include biometric data, location data. You know, we saw that episode where location data revealed the location of military sites. So, you know, people can use data in unexpected ways, and it's not our job to try to anticipate every single way that data can be used. There's a principle called differential privacy, which states if data is to have meaning, then it is in some way contributing to you being able to use it to identify a person. So the only safe data is to have no data at all with no meaning, and that's obviously no use. So the legislation sort of sets lots of conditions about reasonableness. What could you reasonably expect somebody to do with the data? If you've pseudonymized a set of data and you're using it for analytics, then that's great. But if that's a health data set and you've got detailed information about medical cases in there, and maybe you can correlate that with postcodes, then with a couple of pieces of information, you can very quickly get to the point where you can identify an individual, and that's not unreasonable, and it would lead to health information about that person being leaked, and they wouldn't be happy with that. So it's all about understanding the data and making some decisions about what's reasonable. GDPR also calls out certain kinds of data as being sensitive, and if you're handling data that's on this list, then it just says take more care with this data. You need to be more careful, you need to secure it, and if there are issues with that data, if the data is breached or if you fail to follow the requirements of the legislation, then the fines and the penalties will be more severe if you're using this kind of data. GDPR has a very broad scope. It relates to anybody operating within the EU or offering goods and services to EU citizens. So organisations operating outside the EU will still need to comply with GDPR in order to process EU citizens' data. It separates the responsibilities into data controllers as being the decision makers about the data, and then data processors being the people who actually handle the data. Most of the responsibilities sit with the data processors because it's the data processors that hands on the data, but it's the data controllers to make the decisions about what's the appropriate way to do that. So if that's the kind of the remit and the definition, then I think I'd like to ask a question of the audience now, look for a show of hands. So who works for an organisation that is processing personal data? You sort of hold your hands up, and then keep your hands up if you are processing data on your own machinery or on your own kit in the cloud, if you're doing that. And then keep your hand up if you process data on your own laptop, on your own physical device. Okay, we've still got a few hands up. So those two people at the back there, they've got to be the most trustworthy people to process personal data. So I've got some personal data here in my wallet. I'm going to just pass it to those guys at the back there. Can you take care of my data for me, please? And you look after that. And I'd like to get that back in a moment, because it's an extreme example. We don't do that, right? You don't give people your property. It just doesn't happen, but it happens with data all the time. So I need you to be looking after my wallet at the back, thank you very much, because I want to use it to demonstrate the rights of the individual, which is what GDPR is about protecting. So with my wallet over there, then I'd like you to respect my right to be informed. That you've got my wallet, and I need to know that you're going to take care of that. So thank you very much. The right of access, I will get that back if I want it. To rectification, if you take some money out of that wallet, I'd like you to put that back if I ask you to. Thank you very much. The right to erasure, It just means I don't want you to have that wallet anymore. Give it back to me. To restrict processing, if there's things that you can and can't do, that I can be in control of those rules. Data portability, I want it back, or I want somebody else to have it, pass it to the person next to you and they can look after it. The right to object, if you're doing stuff with my wallet, then I don't want you to do that. And then the last one, it doesn't really work with a wallet, but it's an important one. So if you make a physical analogy with this data, and the data belongs to the individual and it is the property of that individual, then none of these rights are unexpected. This is exactly how you would expect people to behave with your property. So that's really the key message is treat it as if it's property placed in your custody. So I'm going to call my right to erasure now, and can I have my wallet back? Thank you very much. Thank you. So it's a shame it was right at the back. It's a long walk. So those are the rights of the individual that GDPR puts in place, but actually privacy regulation goes way back. 1980. Imagine the world, the IT systems that would have been in place in 1980, and already, the OECD guidelines actually had, I think, 7 principles for handling personal data. And they're basically the same as the rights of the individual in GDPR that I just showed there. Nothing has changed. This legislation has been in place for a long time. People have expected organisations to handle data in this way. And to be honest, people haven't been doing it. There's a whole string of legislation, the Data Protection Act, and organisations have been paying lip service to it, following it where it suits them, but where it doesn't, you find justifications for doing things differently. What GDPR is really doing is rebooting the existing legislation. It's just being more clear, and it's putting bigger fines and bigger penalties, but also empowering the ICO and the other enforcement organisations that they're actually going to follow through on this now. And organisations' behaviour needs to change for personal data. And so that's something that we're all experiencing the pain of. We've got to find out where the data is. We've got to go through these compliance audit exercises to understand where everything has been processed. If you were designing a system from scratch now, you'd do it very differently. But that isn't the world that these systems have evolved in, and we've got personal data spread all over the place. There have been a whole set of enforcement cases that the ICO has followed through over the years, and I think we just expect this to get more. And the ICO kind of showed that they've got teeth, and they've even got jackets now with logos on the back. They think they're like the FBI, and this is when they entered the offices of Cambridge Analytica and seized their data. Can you imagine the things that they've been shouting? Freeze, step away from the consent boxes, hand over your audit data. But why are they doing this? So they're trying to protect individuals' data. I have been a victim of identity theft. This is an email that Yahoo sent to me. They sent it to me on the 11th of 2017, so November last year, and it related to an incident that happened in August 2013. So not really a very timely notification, and just, we have determined that your user account information is also likely to have been affected in this breach. Very, very vague. What can I do about it? I could change my password. I had used that Yahoo password on a number of different places. I had to go around and change those passwords. It was an inconvenience, but it was Yahoo, and it was my name and my email address. And I did have a Flickr account, and somebody could have uploaded some photos but it wasn't a big impact. But it can be. You know, people can take somebody's identity and then use it. It can have financial implications, reputational implications. People can be affected by this, and this is data that's stored in your databases, and we need to respect that, and we need to take care of that. So, you know, there have been some very, very big examples where this hasn't happened. So the Yahoo example, 3 billion user accounts taken there, and you know, I've done some research. I haven't found a convincing explanation of how it happened. We'll give them the benefit of the doubt and say that, you know, it's a state-sponsored actor who got that data. There are organizations and people out there who can get data if they really want it. You know, zero-day exploits and mechanisms to do, if the data is important to them, they're already in the system and they're already in a position where they can get the data if you need it. You have to have that sort of mindset to protect against the most determined hackers, and it's all about minimizing the impact. So that's, you know, the state-sponsored actor who's really serious and has a lot of resources around them, but that isn't how the majority of data breaches happen. They're opportunists. So EQUIFAX, 145 million accounts exploited because they didn't patch their Apache struts. So, you know, you find the version of struts that they're using, look up the vulnerabilities on the CVE database, and then find the script on GitHub that will tell you how to exploit it, and you can get in and get data. You know, there can be some very, very simple ways in. Adult Friend Finder is an interesting example. A lot of people know the Ashley Madison case, where I think 32 million accounts were stolen. With Adult Friend Finder, across their entire group of dodgy companies, 412 million records stolen there. And that was an exploit, local file inclusion. They weren't cleaning their inputs. They had some dirty files being uploaded, you could say, which they probably should have expected. But it wasn't just that. They then had either no hashing on their passwords, or they were using weak hashing. And once people were in, they were able to get passwords very simply and then download them and then post them for anybody to see. So again, very, very simple exploit. Uber, 57 million records stolen there. They put the password to their production S3 bucket committed to GitHub. And you know, any developer in the room is just screaming, no, you don't do that. You don't put production passwords in source control. Everybody knows it, but it happened, and their Git account was compromised, and then the attacker got the GitHub passwords. So I think the lesson for me from this is it needs to be the people who are actually processing data. It's people like us, the devs, hands-on, who know the processes, who know the systems, who know where the data is. We're the ones that need to call this stuff out. It can't be a box-ticking exercise at board level. Yes, we've got compliance. You know, these are simple, routine mistakes. To err is human, and we all need to be on the lookout for when this happens. And we need to call it out. And so, you know, in this new world, 2018, GDPR regulation, personal data is more prevalent, and when it's in our systems, we need to take care of it. And so some things are now should be considered unforgivable. So if you've got personal data that is not encrypted at rest, it's not encrypted in transport, then you should be calling that out. You know that's wrong, and you should be saying, stop, don't do this. You know, we all need to take this responsibility. If we're looking at, you know, personal data that's putting it on a USB stick or a drive and carrying it around, no, that's a stupid thing to do. You know, don't do that. Just stop doing it if you're doing that. If you're using personal data for testing and you haven't got the same controls on your test system as you've got on your production system, You shouldn't be handling that personal data on your test systems. Stop it. Call it out. It's time for these things to end. And as developers, there's a certain set of practices that we should all be aware of. You know, the OWASP Top 10, the Application Security Project, basic principles to stop SQL injection, and a lot of those hack principles that we saw the major breaches happening with would be cleared up if developers take care of the basics. Yeah? So this is on all of us to do this stuff. There's other things that we might see. We might see hoarding of data going on, and we might think that's really bad. And we'd see spamming of emails and these things going out. But I want to classify these things differently, because there'll be people in your organisation, and for them, that data hoarding is their business intelligence, and that's not going to be something that they're going to let you just make a decision, call it out, we should stop this. That spamming is marketing, and it comes down to a point that, you know, really, it's a decision. It's a fight between the technical capabilities that we have, the interests of the business, and the compliance demands. And it's always that three-way decision about what is reasonable. It's a balance. And sometimes the rights of the organisation and their legitimate interests are necessary for you to process that data. And that's really what's kind of encapsulated in what GDPR calls lawful bases for processing data. So I talked about the purpose earlier. I referred to why is data being processed. It's always about what the purpose, and then you use that purpose to then derive your lawful basis for justification. So a legal obligation is a straightforward justification. I need this for financial records, for tax purposes. Financial services have to collect a lot of personal information to comply with money laundering regulations. Charities need to collect records to establish gift aid. So there's a lot of requirements placed on organisations for them to have personal data. So legal obligation is a common justification for processing it. You still have to take care of it and protect it and secure it, but that's the reason that you're doing it. Another basis is contract. Very, very common one. You've got a contract in place. You're going to provide a service, or also an inquiry to provide a service before a contract is in place. So a quotation process can require collection of personal data, and that's perfectly justified. Legitimate interest is more interesting because it's not so clear-cut. You haven't got a legislation that you can refer to and say, I'm doing it for that. You don't have a written contract in place that says this is the service that I'm performing, but your organisation has a legitimate interest. I think this is going to be a very commonly used legal basis for processing. A lot of people talk about GDPR with consent, but actually I think legitimate interest is the more common basis that's appropriate, and we'll talk about that a bit more. Because people talk about consent, and this is I think consent is often considered to be the last resort. If you haven't got one of the other bases above, then you fall back to consent. But consent is hard, and consent has some very stringent requirements on it. And then there are a couple of others which, if they're appropriate for your organisation, then you'll know and you might do it. So public tasks for sort of local government and organisations like that, and then vital interests of the individual. So if you turn up at A&E, nobody's going to ask you for your consent to check your medical records to give you the blood transfusion that you need to save your life. So when they apply, it's obvious, but for the rest of us, we're dealing with the top four. And I'm not a lawyer, and I would summarise the way that we deal with all of these legal bases is vaguely these three hand-waving argument. I'd say, what's the purpose? Does the purpose establish the appropriate legal basis? A necessity test, do you need that data to be able to perform that purpose? And then there's some kind of balance, proportional use, reasonable criteria that you're not doing something that the individual would not expect you to do with that data. And so that's often a sensible way. So a really good example of doing this is IP address. People got very kind of heads up about IP addresses. If you can identify an individual from an IP address, then I've got to be able to delete IP addresses from my entire system, and we need to be really careful what we do with IP addresses. And again, you're not thinking about it the right way if that's the questions that you're setting yourself. It's about what's the purpose? What's the purpose of me processing this IP address? What am I doing with it? If I'm logging the IP addresses in my web access logs, because on the internet protocol, the only mechanism I have of identifying the person who's talking to me on TCP is their IP address, and I need to protect my web systems from the possibility of them being attacked, then storing that IP address is entirely reasonable. Individuals would expect you to protect your web-facing systems, and you need IP address to be able to do that. That's it. That's perfectly reasonable, and everybody should be securing their systems and logging IP addresses and looking for anomalies with IP addresses. If the purpose of you processing IP address is to try to profile an individual using an internet browser because they've turned off cookies and they've turned off the other tracking mechanisms that you could have put in place, and all you've got left is the IP address, then that's a really shoddy identifier, and you're desperate to try and track their identifier. And then you would need some very, very good justification to demonstrate that that was a reasonable use of that data. So it's all about purpose. And whenever people say, can I process this data, we should all get in the habit of saying, well, what's the purpose? You start with the purpose. So once you've got your legal basis, then there's a set of criteria that are more explicit than my rough 3-point guidelines. So I said consent is a very hard thing to do. And there are some very stringent requirements placed to make consent valid. And it's about placing a question. Would you like us to do something with your data? And you can say yes or no. You have to pose that question. It has to be something that puts the individual in control. And consent is something that we use in our systems to engage customers. It's an opportunity to go to your customers and empower them, and you can build trust in the way that they use your data. It's an opportunity to engage customers. That's the best way of viewing this process, to get the most benefit out of it. But you do have to have good records when consent is given. You have to know when and how. You have to know the wording that was put in place, and you have to keep those records, and you have to set a time for when that consent will expire. And if you're collecting it electronically, then you need to provide an electronic mechanism for consent to be withdrawn. It needs to be as easy to withdraw consent as it was for it to be given. So consent has lots of conditions around it. And then legitimate interest is this cause of saying, well, this is my legitimate interest and this is a valid thing to do. So you're not asking a question, you're making the statement. We are going to do this with your data, but you can tell us that you don't want that to happen. So you still have to provide a mechanism for them to opt out. But importantly, you can't just claim a legitimate interest and then just go on and do it. You can expect an auditor to require you to demonstrate that you have assessed that your legitimate interest is valid. And the way that you do that is you complete a legitimate interest assessment, and it has 3 tests: the purpose test, the necessity test, and then the balancing test, which demonstrates that your legitimate interests are appropriate and the reasonable expectations of the individual and are balanced against their rights as an individual. And you have to have done that to be able to process data as a legitimate interest. But having done that, it enables you to make the statement, we are doing this, but you can opt out if you want to. So very often, that is the most appropriate way for organisations to process personal data. You do have to review it occasionally, and your legitimate interest doesn't last forever. It does need to be refreshed and reviewed. And then there's this condition about being online. If you're doing most of your processing online, then you should offer an easy way to opt out that should be online. So all this is great, and it's all very clear cut. But then you get to direct marketing, which is where so much of the debate around GDPR has happened. You know, what do we need consent? Can we process this under legitimate interest? And it's not just about GDPR. There's different legislations that come into play. So GDPR is very clear. Recital 47 says direct marketing can be a legitimate interest. You make that balance assessment of legitimate interest and rights of the individual, and you can do direct marketing, send communications to individuals as a legitimate interest. But there's another regulation called the Privacy of Electronic Communication Regulation, PECA, which says electronic communication requires consent. So if you're going to do that direct marketing via electronic communication means, then you require consent. But then there's a special condition in PECA. There's this thing called the soft opt-in, which has a whole load of constraints around it. It's for people where you have a existing commercial relationship, and when you establish that relationship, you gave them the opportunity to opt out of direct marketing communications, and in every subsequent communication that you've ever sent, you gave them the ability to opt out from that communication, then it is valid for you to send direct marketing by electronic means. So it's ridiculously complicated, but the end result is that if you've done it properly and you've respected the rights of the individual and provided opt-outs, you can use legitimate interest as a basis for doing direct marketing using email with the appropriate caveats and processes in place. But there's a new regulation coming in. We don't know the timescale yet. It's called EPR, Electronic Privacy Regulation, and it's the next version of PECA. And it's not finalised yet, but it looks like that's going to be very clear that you will require consent to send electronic communication. And so when that regulation comes in, this soft opt-in and these various options will all change. So I think, you know, the best advice at the moment is use legitimate interest for your direct marketing, but use legitimate interest as a bridge to consent. You know, we should be asking people for consent. Consent is a way to engage customers, and it's a better basis for processing if we can get it. So having been through all of these assessments, then, you know, we need to start communicating with individuals, and we need to do this clearly. So there's some good UI design practices that we can follow. I think this is a nice, clear example of a site that does it well. And the important thing is separate out the different things that you're doing. So if I'm agreeing to terms and conditions, you know, then that's here. That's me putting the contract in place, and then down here I'm asking for contact permission. I'm asking for consent. That separation, that your consent is separate from the service, is a really important design goal that the ICO and the guidelines that they say always put in place. And then there's a design pattern called layering, where you know, you can expose more details for customers who are interested. You know, there's a lot of stuff that we have to do here, and we don't want that to get in the way of customers' journeys through the website. Don't make me think. I just want to get through this. So those are all valid design goals of websites. But if people want to know more, they should be able to discover it. So, with these kind of, it's just an expanding section of a website that reveals more information and then has a link through to a site, to a page that's got even more information if somebody is really interested. That's an appropriate way to present it. And then there's sort of just-in-time design principles. Don't disturb people. Don't overwhelm them with an assault of information the first time they look at the page. It's sort of as you move through this form, there's pop-ups that provide information in context. And these are all ways that you can minimize the impact on users and keep your website performing well while still complying with some of these regulations. Animation. So there's lots of work to do on web design, and then there's paperwork. There's just some audit stuff that we need to do. We need to record our processing activities. We need to do the data privacy impact assessments. If we're handling data, then there's a whole set of things that the guideline says needs to be considered. And for all of this stuff, I would say, the Information Commissioner's Office website is really, really good. They set up their GDPR guidelines a couple of years ago. It was really rough and ready. They've just iterated on that over the last couple of years, and they've just improved. And now it's a really good resource with lots of very, very useful information. It's not too complicated, and it's something that we can all use and start with their templates for how to do this stuff and use that information. It's a great resource. And then there's some guidelines of privacy by design, which I find these a bit too high level. They don't really give you some pragmatic advice, but I think it's useful to call out the principles that are here. So proactive, not reactive. Start thinking about data privacy at the start of a project, not at the end of it. It's not something that's easy to clean up. I think the end-to-end life cycle protection, that covers so much that's really important to do. At the beginning of life, you should be looking at data minimization. Don't store data if you don't need it. That's within there. And then end of life, proper deletion of data and review when you still need data and get rid of it if you don't need it. So there's a whole load within that bullet point that people should be doing. And then I really like the positive sum approach, avoiding dichotomies. It means, if you're providing a service, don't do what so many organisations do seem to do. It's like, well, you can use this service or not. You can have the benefit of my service, or you can have data privacy. I'd like both. So why not? Why does it have to be, this zero sum? And quite often you see different players on the internet take very different approaches to this. So Google, a lot of their checkboxes and consent options are just use the service. You've got an OK button and then a small cancel link, and then that just terminates the process, as opposed to a lot of the Apple products, which will ask consent to do specific things at the point in time. And if you say no, then that feature of the app doesn't work. So there's a whole range of techniques that can be used for asking for consent and processing data, and some of them are better than others. We should all aspire to do them better. So I'm going to wrap up with just a few closing thoughts. So really, processing personal data is respecting the rights of the individual. That's paramount. This is important stuff, and we should all take it seriously. And we should treat people's data as it is their property. It's not unreasonable when you think about it in that way, and we do have a responsibility to these individuals. Design for privacy up front, it's not an afterthought. If you were designing systems now, you would do it very differently from how we've done it in the past. Microservice-based architecture, personal data at one place, and then link in from other places. That's not the situation that most of us find ourselves in. But moving forwards, I think that's how systems will evolve. And compliance, if you're getting tied up in legal arguments, you probably need to take a step back and just think about this a bit more. It's about what is reasonable. And if you can find a way to think about the purpose and the rights of the individual balanced against the rights of the organisation, there's a common sense approach. And it's probably not our decision as developers to make that final call on what's the right thing to do, but we can ask the right questions. And then that really is just sort of understanding responsibilities. We're mainly going to be data processors rather than data controllers. And a lot of this stuff is, it's not core to our business. Compliance is not something that we want to be doing in our day-to-day lives. We want to be delivering features that deliver value to customers. And so if we can find ways that we can concentrate on that, then that will make us more efficient. And so using external data processors, and I think the best example of this would be login boxes using OIDC. Find an identity provider that you can use. Log in with Facebook, ironically, but it's those people can manage the personal data. They secure the passwords. You can use those systems, and you don't have that personal data in your system anymore. It's coming from that identity provider. It's a really good example of externalizing these data processing activities. So just wrap up with some links. So consentric. Check out the website. We process personal data. We can secure it. We handle those personal rights. So come and speak to us about consentric. We're at the stand downstairs. And also, do check out that ICO website because it's a fantastic resource. It's got some great information. So thank you very much. Any questions? Yes.
When you were handing your wallet out, you were looking for someone who was downloading data onto their own machine. Is it kind of a bit more blurred if, like we do a lot of data NTL work on other people and our customers' hardware? Are we still processors? Is it still that clearly defined? Or are we doing it on the request of a customer? Are they still processing and they've kind of sat project out to us?
So the question is, if you're processing data for a customer on their hardware, on their equipment, does the legislation still apply? And I think, yes, you're a data processor. If you're, I don't know what the exact definition is, but you're the people operating that, regardless of where the kit is, you have obligations as a data processor, yes. Any more? One more?
Yeah. Is there any discussion on whether back-end batch processing should be checking consent before processing records? Has anyone thought about that yet?
So the question is, should batch processing check consent? And yeah, absolutely. The purpose of processing needs to be defined and understood, and then if you need consent, or if you decide it's legitimate interest and they can opt out, then those records need to be checked and the appropriate things put in place. If your batch processing is processing that personal data, maybe making decisions or enriching that information to then use that to make decisions about that person, then it affects them and they've made a different choice. So yeah, it should be looked at. Yeah. Yes.
Are peer-to-peer applications and the scope of this, like, will some experimental social networks that put people's data across like users' machines? Do you know if that's in the scope of GDPR legislation?
So the question is, does data that's transferred in peer-to-peer networks fall within scope of GDPR? And I think absolutely yes. The scope's clear, it does, but what technical capabilities and what's reasonable, a lot of those things that they're not really going to be decided until we get the first cases that are tested. I think we just have to do your best at anticipating what's reasonable until a lot of these things get clarified, unfortunately. Yeah. Yes, right at the back. So the question was, is the definition of personal data the same as the Data Protection Act, and can you indirectly identify people? And yes, you can. That does count. It's clear that if you can put together a number of different identifiers to establish an individual's identity, then that's personal data. But there's a condition about what's reasonable and how much you can do with that. So yes. There's the question here.
So the company is storing data about a person for a client. Is it supposed to provide mechanisms to delete that data to the end user himself? Or do all requests have to come through our client who actually gave us the data?
So the question is, if you're processing data for a client, do you have to provide a mechanism for the end user to delete the data, or do you do it on instruction from the client? And I think in that case, it's going to come down to the nature of the relationship with the end customer. If you're providing an online relationship directly to the end customer, and most of their transactions are done with you online, then it would be more reasonable for them to expect to have an online mechanism to initiate that right to erasure. So again, it sort of depends on situation and circumstance. Yes?
Yeah, I have a question around backups. So
Yeah.
personal data, if someone decided to opt out from your system, how do you remove them from backups?
Yeah. It's a very good question about removing personal data from backups. I think, again, it's about what's reasonable. So in the majority of cases, if you remove data, you make it's enough to make it unavailable for further processing. That's what the individual is expecting to want in this situation. So as long as the processing stops and that data is not available anymore, it doesn't get processed, then that's okay. And removing data from backups is such a laborious and very, very difficult thing to do. I don't think that was going to be considered as reasonable in the vast majority of circumstances. Yeah. So, yes.
What's my responsibility for third parties that I'm included on my web page? So maybe adverts or analytics. The user may not be aware.
Yeah. So the question is about third parties like ad providers on the website, and what's your responsibility as the owner of that website, as the provider. So you're the data controller. If there's personal data, tracking cookies and other details, they're being passed to those, then you have a responsibility to notify the user that that's what's happening, and give them a mechanism to opt out if they don't want that to happen. I think it's a lot of these things, they fall under the bucket of legitimate interests. So it's a legitimate interest to put adverts on a website. The users of the website would reasonably expect adverts to be there because we all use the web for free. But if our data is being aggregated and profiled and we're being tracked from one website to another, then actually, a lot of us feel that's a bit creepy and that we'd like to be able to opt out of that. So it's about, putting the appropriate measures in place and allowing people to opt out. Informing individuals is the important step. Any more? Or should we wrap up there? Okay, thank you very much.